Good afternoon, participants. I am Bhuvan Arora. Though my introduction has already been, must have been already given by Sonia. Uh, I will just, without wasting time, I'll start the webinar and I'll focus mainly on the delayed payments. What are delayed payments? How they are delayed? What the buyers do? How we can recover those delayed payments? What are the challenges? And what are the solutions that, if implemented, we can get our delayed payments on time? So highlights of today's webinar will be, first, the challenges faced by MSMEs while doing business, thereby affecting their recovery. So what sort of challenges are being faced by MSMEs? Whether it is with respect to payments, whether it is with respect to delivery of goods, whether it is with respect to the documentation, I will cover all those things. Whether it is with respect to, affecting the profitability, low margins, So second point is solutions which are available to MSMEs. So there are two type of solutions. First is internal. If we do those internal changes within the organization or within our company, then how we can quickly recover our debts. The other one is external. By external, we mean going to the court, approaching the court of law and getting our payments from there. Third, very important aspect which I'll be covering in today's webinar will be the newly introduced section 43BH of the Income Tax Act. Why this act, why this new section was introduced? What is the purpose behind introduction of such act? And last but not least, you please stay connected with the webinar. I'll give you some quick, speedy, quick tips for speedy resolution of delayed payments. If we do all these, the tips, then we will definitely be able to recover our delayed payments. So let's start with the challenges. So what are the challenges? I will not be focusing on how you are growing your business and how you are making profits, how you are attracting your customers. I'll only focus on the challenges. So first and major challenge is delivery of material without purchase order. So what happens in most of the clients, I keep getting calls from my clients कि boss मेरे को phone आया मेरे customer का, उन्होंने phone पे ही बोला कि ये माल भिजवा दो, and I have sent that goods to the client. Now he is not making any payment. So my answer to them is that in this case, in the absence of purchase order, you will not be able to recover your dues. Why so? Because if we approach court, court will ask for the documentation. The first and foremost documentation will be purchase order. So I always, say to MSMEs, to all the entities, that this is one of the major challenges. How you will overcome that, we will cover in the next coming slides. Second challenge is competitive market leading to less margins. In every business, whether it's a textile market, whether it's a sugar industry, whether it's any other, industry, number of players are there. As a result of which the customer becomes the king. Why? Because customer knows that if A shopkeeper is not giving me goods at a competitive price, I will, switch to a B competitor. I'll get my goods from B. If he wants to stay in the market, he will definitely give me a good competitive price. So a good competitive price will make the margins very less because you are operating at a competitive market. Third challenge is ineffective follow-up. अब ineffective follow-up में क्या होता है? Goods तो deliver कर दिए या services render कर दी, उसके बाद हम सो जाते हैं. हम सो गए, हमें 1 महीने बाद, 2 महीने बाद, कभी 6 महीने बाद कुछ पार्ट पेमेंट्स आ गई, फिर हम सो गए, हमने फॉलो अप किया उनसे. देयर इज नो डॉक्यूमेंटेशन, देयर इज नो, वी जस्ट कीप ऑन फॉलोइंग अप विद देम ओवर कॉल्स. तो व्हाट हैपेंस, हमारा जो फॉलो अप होता है वो बहुत इनइफेक्टिव होता है. क्लाइंट भी भूल गया, क्लाइंट भी 10 हमारे जैसे कस्टमर्स से डील कर रहा है, कहीं से परचेज कर रहा है, कहीं से कुछ सर्विसेज रेंडर कर रहा है, तो उसके भी बहुत सारे वो हैं, सेलर्स हैं. तो क्या होता है, ineffective follow-up is also a major challenge. Next is, as a result of the above, there is difficulty in getting payments. clients will give reasons one or the other, because they know they don't want to give payment at the time when they are issuing the purchase order, या जब वो माल खरीदने आएंगे तब वो बहुत बड़ी बड़ी बातें कहेंगे कि पेमेंट्स हमारी 90 डेज में हम दे देंगे, या 10 डेज में दे देंगे, या एडवांस दे देंगे आपको। एक बार माल चला गया, उसके बाद आप फॉलो अप करते रहते, वो क्लाइंट पेमेंट नहीं देगा। लास्ट इज कैश ट्रांजैक्शंस। मोस्टली ऐसा भी होता है कि हम लोग कोशिश करते हैं कि हम अपना कुछ टैक्स बचा लें, या चीजें होती हैं बिजनेस में, बिकॉज नो बिजनेस इज विदाउट एनी कैश ट्रांजैक्शन, नो बिजनेस कैन रन। सो व्हाट हैपेंस इन दोस केसेस कि मैंने माल दे दिया, अब क्लाइंट से कैश आना था, पेमेंट आनी थी, ना मैंने परचेज ऑर्डर मंगवाया, ना मैंने इनवॉइस जनरेट नहीं किया। तो जब मैंने इनवॉइस जनरेट नहीं किया, वो आनाकानी करने लग गया। तो क्या करा जाए उसमें? तो दीज आर सम ऑफ द चैलेंजेस। नेक्स्ट प्लीज। as a result of as a consequence, I would say, of all these challenges being faced by MSMEs, हमें क्या problems आती हैं? There is low business income despite decent amount of turnover. Turnover तो हमारी बहुत अच्छी है, but इतना पैसा फंसा हुआ है मेरा मार्केट में क्योंकि मैंने ये अपने challenges को overcome नहीं किया। उसकी वजह से मेरी profitability भी low है, मेरे पास liquidity crunch है। अब लिक्विडिटी क्रंच है तो मैं और माल भी ऐड नहीं कर सकता, और सर्विस भी रेंडर नहीं कर सकता। सो दैट विल इफेक्ट माय बिजनेस ग्रोथ। नेक्स्ट। सो ऑल दीज चैलेंजेस फ्रॉम दीज सॉल्यूशंस इफ इम्प्लीमेंटेड will make the recovery of your payment much easier and much faster. So as I told you at the beginning of the webinar, there are two solutions available to us. One is internal. Internal means solutions which are available within the organization, within my company. I need not have to go anywhere. अगर मैंने वो solutions implement कर लिए तो मेरी जो रिकवरी है वो बहुत इफेक्टिव हो जाएगी और मेरी बैड डेट्स रिड्यूस होगी। सेकेंड इज एक्सटर्नल। एक्सटर्नल मीन्स ऑल्टरनेटिव लीगल रेमेडीज जो मेरे पास मेरे कोर्ट ऑफ लॉ में मेरे पास अवेलेबल हैं, जो मेरी लीगल रेमेडीज है, मैं किस कोर्ट में जा सकता हूँ, कौन सा केस फाइल कर सकता हूँ, वो सब चीज हम एक एक करके डिस्कस करेंगे। नेक्स्ट। So first we will cover internal. What internal measures are there? First is purchase orders to be made mandatory. जैसे मैंने चैलेंज में बताया था कि परचेज ऑर्डर नहीं होते। अब काफी क्लाइंट्स कहते हैं कि मेरे को फोन आया तो मैंने फोन पे ही उनको माल भेज दिया। उसमें आपको क्या करना है उन केसेस में? बाकी केसेस में तो आप ईमेल पे और उन पे मंगवा सकते हैं, बट उस केसेस में व्हाट यू हैव टू डू इज यू send a WhatsApp to the client कि आपने ये क्वांटिटी इतने रेट पे मंगाई है, प्लीज कंफर्म, एंड कॉल द क्लाइंट कि इस पे आप कंफर्म कर दो, क्योंकि मैं डिफरेंट रेट्स ऑब्वियसली कोट करता हूँ हर कस्टमर को, तो आप एक बार कंफर्म कर दो और मैं इसको आगे प्रोसेस करा देता हूँ। तो वंस द क्लाइंट कंफर्म्स दैट, इट बिकम्स अ परचेज ऑर्डर। तो यू हैव टू, एज एन एंटरप्रेन्योर, एज एन MSME, you have to place more. In other cases wherein there are big entities, तो वो ईमेल पे या वो परचेज ऑर्डर्स इशू करते हैं, तो उस केसेस में कोई प्रॉब्लम नहीं है। तो वन फर्स्ट इंटरनल मेजर इज ऑलवेज यू हैव टू इंसिस्ट फॉर इशुएंस ऑफ परचेज ऑर्डर। सेकंड, आप परचेज ऑर्डर में ये देखिए कि पेमेंट टर्म्स क्या है। क्या मेरा 100% एडवांस अमाउंट है, या इट इज अपॉन डिलीवरी, या बैलेंस कितने स्पेसिफाइड पीरियड में आना है। सो ऑल दोज यू हैव टू चेक। वंस यू चेक, immediately basis that you can get your payments and you can ask upon the client to pay, because that is what is written in the purchase order. Then acknowledgement on the invoices billed to the buyer. Why this is important? जो मैंने इनवॉइसेस क्लाइंट को भेजी, अगर तो मैंने ईमेल से भेजी है तो कोई प्रॉब्लम नहीं है। अगर मैं बाय हैंड थ्रू जब मैं मटेरियल भेज रहा हूँ उसके साथ ही मैंने इनवॉइसेस भेज दी हैं, तो उसकी एक्नॉलेजमेंट जरूर लीजिए, क्योंकि आगे अगर आपको रिकवरी में इशू आएगा तो कोर्ट इस एक्नॉलेजमेंट के थ्रू उससे एक्सेप्टेंस करवा लेता है कि आपने एक्नॉलेजमेंट करी हुई है इनवॉइसेस पे, दैट मींस यू हैव एक्सेप्टेड दैट बिल, सो यू कैन नॉट डिनाई नाउ। देन रेगुलर फॉलोअप्स ऑन ईमेल्स, व्हाट्सएप। हम लोग यूजुअली क्या करते हैं, हम लोग फोन पे बात करते हैं। हम कहते हैं सर मेरी क्लाइंट से बात हो रही है, वो कह रहा है अभी मैं बाहर गया हुआ हूँ, अभी मैं एक हफ्ते बाद करूंगा, अभी बिजनेस में प्रॉब्लम चल रही है। फोन पे रेगुलर फॉलोअप्स होते हैं, बट ईमेल या व्हाट्सएप्स पे नहीं होते, क्योंकि हमें लगता है कि नहीं शायद मेरा बायर खराब ना हो जाए, कहीं मैं उसको व्हाट्सएप पे बोलूंगा यू आर नॉट मेकिंग पेमेंट प्लीज पे। फोन पे तो ठीक है, इनफॉर्मल होती है, बट आपको फॉलोअप्स ईमेल और व्हाट्सएप्स पे भी करने हैं। अगर क्लाइंट का ईमेल नहीं है तो ऑलवेज फॉलो अप ऑन व्हाट्सएप। देन नेक्स्ट, वी हैव टू ऑब्टेन बैलेंस कंफर्मेशन फ्रॉम द क्लाइंट। वाई सो? इसका भी एक तरीका है। वाई सो? बिकॉज वंस क्लाइंट कंफर्म्स द बैलेंस कंफर्मेशन, he is admitting the dues to be paid by him. In that sense, we can go to the court if he is not making payment, and within no time, court will issue an order and court will, order for recovery. So how we can take that balance confirmation is we can send them an email that our audit is going on. Our auditor wants to confirm that these are our debtors. So please confirm the balance. So A, you are not asking for money. B, you are only asking for balance confirmation. So in any which way, he will not be reluctant to give you confirmation of the outstanding which is due from him. Next. So these were internal measures. Now we will come to external measures. If even after doing or even after taking into account all the external internal measures into account, even then if we are not able to get our dues, because there are customers, there are buyers who are, who will say, okay, I'm not giving you any payment. If you want to approach the court, you approach the court. Then what is the solutions available for you? So first is Micro and Small Enterprises Facilitation Council. So these facilitation councils were established under the MSMED Act 2006. MSMED Act means Micro, Small, Medium Enterprise Develop Act 2006. So they were established, and the role of MSEFCs is those micro and small enterprises. Why I say MSEFCs? Why not MEFCs? Because it only takes into consideration micro and small enterprise. So medium enterprises are not covered here. So what is the purpose? If the buyer is not making payment, we have to take into account, we have to, attach the purchase order, we have to attach invoices, file a reference before the MSEFCs, and MSEFCs will act as the facilitation council, and they will help. They will call the buyer, they will issue the notice, they will help us in getting our delayed payments. Second recourse is under the Insolvency and Bankruptcy Code. So this code is not that old. It was, it came into effect in 2016. So the purpose of this code, and it's a very effective code. Purpose of this code is if there is a default, if delayed payment is there and if there is a default, the buyer is not making payment, then you can approach this court. NCLTs are there, National Company Law Tribunal. Then you can approach the courts and seek the insolvency of the corporate debtor, of that debtor. We will cover in detail once I will brief about the insolvency and bankruptcy in the coming slides. Third option available is check bounce cases. So if the buyer has issued me a check and he has not made payment, or his check has bounced, then what recovery measures are there? Whether I can go for recovery of that case by filing a recovery suit, or I can go for check bouncing cases, or both. So that is also an option that we have to see basis case to case, facts of the case. So check bouncing cases are also there under section 198. Then arbitration between the parties. Sonia, somebody is saying that my voice is not clear. So am I audible?
Yes, sir.
Okay. So next is arbitration between the parties. So how arbitration helps? arbitration will help so this is also a scheme, designed by the government in the act. So what happens is, if there is an agreement between the parties, like purchase order, right? So whenever there is a arbitration clause, so parties, in case of any dispute, parties are referred to the arbitration, wherein a third party, a neutral party, unbiased arbitrator is appointed, and he will take into account all the issues faced by the buyer or the seller. He will adjudicate, and within 1 year or so, he will pass a arbitration award. So why this arbitration helps? Because if we approach the court may take 2 years, court may take 5 years, but arbitration will be, lesser than what court will take. So that is also one of the legal grounds which we can invoke whenever there is a agreement. Last but not least, suit for recovery. If my payment is stuck and I am not covered in any of the above external measures, then what I will do? I will file a suit for recovery. So suit for recovery are also majorly categorized into two heads. We will take care of that also in the coming slides. Next, let us see how each court or each option, external option, will help me in recovering my delayed payments. So first is reference to micro and small enterprise facilitation councils. It is there embedded in the act that when a buyer buys good from a supplier and he is not making payment within 45 days, then he is liable to make payment, delayed payment with interest, which will be 3 times the bank rate at compounding monthly rests. So what does that mean? If I have taken a material from a supplier, suppose on 1st of January, and I have not made payment by 15th of February, which is 45 days, then whenever I will make payment to the supplier, I will have to add interest, which will be 3 times the bank rate. So bank rate keeps on changing from time to time. So section 15 says, where any supplier supplies any goods or renders any service, the buyer shall make the payment on or before the date agreed, or within 45 days from the day of acceptance or day of deemed acceptance. So in cases where there is an agreement, that agreement says, okay, I will make payment within 30 days or within 20 days or within 7 days, then that will be applicable. If not, then 45 days is the outer limit. So within 45 days, the buyer has to make payment. Now section 16, if he doesn't make payment, then what happens? If buyer fails to make payment within the stipulated time as stated in section 15, then the buyer shall be liable to pay compound interest with monthly rests to the supplier on the default amount at 3 times the bank rate as notified by RBI. So buyer will be under an obligation through the act to make payment with interest at 3 times the bank rate. Next, if the buyer doesn't make payment, then what will happen? So section 18 covers that. Any party to a dispute may make a reference to MSEFC, which will at first initiate conciliation between the parties. If conciliation fails, it shall either itself take up the matter for arbitration or shall refer it to any institution providing alternate dispute resolution services. So what happens if the buyer is not making payment? So first solution for me as an external solution is making a reference before MSEFCs. There is no amount, there is no threshold which is determined by the MSEFCs that no, the default has to be 1 lakh or 10 lakh or 50 lakh. No, any default. So what I will do is, if the buyer has made default, I will make a reference to MSEFCs. MSEFC, once I make a reference, they will immediately issue notice to the buyer that you have defaulted and you are given time to make payment. Otherwise, the case will go and you are advised to appear before the court on such and such date. So that notice is immediately gone as and when I file a reference. So in most of the cases, we have seen that buyers come forward because nobody would want that they will enter into unnecessary litigation, because the act is for micro and small. So maybe dues would be 1 lakh or 5 lakh. And if I am a company of say 100 crore or even 10 crore, so for 1 lakh rupees, I would not want any litigation, because even for 1 lakh, I will have to end up spending, some amount for my lawyer also. So I would not want. So what happens? They will first initiate conciliation. Conciliation means a mediation sort of a thing. They will call both the parties on the first date. They will ask both the parties how much is the due, legally what is due and payable, and why don't you settle? If that conciliation fails, then there are two options. Either the MSEFCs will take up the matter for arbitration by themselves, they will act as the arbitrator, or they will refer it to any institute which provides that facility. So maybe they will refer to the, like in Delhi, we have Delhi International Arbitration Center, which is in the Delhi High Court, which provides for all alternate dispute resolution services. So they will refer to that if the case is in Delhi. Now, what we have to note, important points if we want to file a reference under MSEFC. First is MSEFC to have the jurisdiction in terms of supplier's place of business. So from where I am situated, from where I am supplying the goods or rendering the services, that MSEFC in my jurisdiction, that will be taken into care of, and I will have to approach to that MSEFC and I will file my reference in that MSEFC. If my buyer, suppose he is in Karnataka or he is in Bombay, so I will not have to go there. Second, every reference shall be decided within a period of 90 days. That is also written in the Act, that every such reference, once filed, will be decided within a period of 90 days. Next, second solution. Next slide, please. Second solution is filing an application before the Insolvency and Bankruptcy Court. Now, what is Insolvency and Bankruptcy Court? I already covered while I was telling you about the external solutions available. Insolvency and Bankruptcy Court means whenever there is a default and the buyer is not making payment and buyer has accepted that default. Most important thing is acceptance of that default. If he has accepted, then I can approach this court and ask the court to initiate insolvency of that buyer or debtor. So this is one of the quickest ways for recovering the delayed payment from your debtors. Why so? Because it is a double-edged sword. So what is the criteria? Criteria is the default. So the minimum amount, the minimum threshold is 1 crore. Earlier, it was before Corona, it was 1 lakh. After that, because many companies suffered, industries suffered due to Corona, so the government, issued a notification and increased that limit to 1 crore. So the default has to be 1 crore. Next is crystallized debt with no pre-existing dispute. So there has to be no dispute. The debt has to be crystallized. Then only I can file an application. Application can only be filed against a corporate. So here the proprietorship concern is not covered. Partnership concerns are not covered. What is covered is corporate. A corporate means private limited companies, public limited companies, and LLPs. What will be the jurisdiction? So the jurisdiction of NCLT. NCLT is the court, which is National Company Law Tribunal. Jurisdiction of NCLT will be based on the registered office of the debtor. So wherever the registered office of the debtor is situated, in that case, the NCLT established in that area will have the jurisdiction, provided there is a default of more than 1 crore and that default is accepted, crystallized by the debtor. Next, Third external solution available to a supplier is bouncing of a check. We have seen in most of the cases that whenever there is a transactions, buyer tend to issue check to the supplier, and later on they get the check bounced. They make that stop payments, or there is insufficient balance. So what is the solution available in that moment? So when a check is bounced, the supplier can initiate a criminal proceeding against the buyer. As soon as the check is bounced, we have to file an application. First, we have to send them a notice. Then we have to wait for 15 days time for their reply. And then within next 30 days, we have to initiate criminal proceedings, which means filing an application before the court. Criteria. Check must bounce within the validity period. So there has to be a valid check. It cannot be a stale check which was issued 4 years back, 6 years back, or even 7 months back. It has to be a valid check within the validity period. Second, we have to obtain return memo from the bank. So as soon as we present the check, if the check is bounced, bank will issue us the return memo. Return memo will contain the answer as to why, or the reason as to why the check was bounced. So that has to be obtained, because that is what is annexed or attached with my application when I approach them. What will be the jurisdiction? So jurisdiction of court is based on seller's bank. So when the buyer has issued me a check and I am situated, suppose a buyer is situated in Kerala and I am situated in Delhi, and I have supplied some goods. So whenever a check is bounced, I will have a bank account in Delhi itself, because I am operating from Delhi. So whenever a check will be bounced in my bank, I will file the case in Delhi court. Like Delhi has 6-7 jurisdictions. So wherever the jurisdiction of my area will be, I will file the case before that appropriate court. Next. Fourth is arbitration proceedings. Arbitration proceedings, as I told you, they can only be initiated if agreement entered into the parties. First of all, there has to be an agreement between the parties. Oral agreement, we cannot go for arbitration. Once there is an agreement, and if that agreement provides for arbitration clause, because usually what happens is whenever there is a agreement, that agreement will definitely provide for a dispute resolution. That if party fails to make payment, or if the other party fails to render goods or services, then what will happen? So it says, if there is a dispute between the parties, the arbitration clause will kick in, and parties will appoint a arbitrator who will adjudicate the case, and both the parties will obey the order of the arbitrator. So if there is an agreement entered into by parties which provides for arbitration in case of dispute. Criteria. So criteria is also written in the agreement, wherein that arbitration clause is written. Usually what happens, jurisdiction of arbitrator is based on the place as referred to in the agreement. So if both the parties are from same state, the arbitrator appointed and arbitration will happen in the same state. They may decide that if I am from south and you are from north, then it depends. Maybe I'll come to south or you will come down to north. So it depends, and it is always written. It is not an oral acceptance. It is always written. Next. Other modes. So recovery has two modes. One is civil suit for recovery, wherein I am simply approaching the court saying that this much amount is due from my buyer because I supplied them goods or I rendered them services. So this much amount is due. The other option is summary suit, filing a order 37 suit. So what happens there? This can only be filed if the buyer has accepted, or if the buyer has issued a purchase order. Why so? Purchase order will contain that these goods at this rate and this quantity has to be supplied to me at this rate, right? So the supplier will supply those goods. And second important thing is invoices. So if purchase order and invoices are there, we can file a summary suit. Even if there is absence of purchase order and there is presence of the acceptance of the amount, then also I can go to the summary suit. I can go and file a summary suit against the buyer. What is the criteria? Jurisdiction of a court is based on principal place of business of the defendant. So here the buyer's place of business will come into picture, or in case a part of or whole cause of action has taken place. If I have supplied goods from my place, then I can also file a case within my jurisdiction. Or if the supply is from a third place, third state, then I can also file a case from a third place. So that needs to be taken into consideration, and that depends upon where the goods or services have been rendered. Next. Okay, so now very important thing, which I am sure you all would be aware of, is introduction of section 43BH, because this section was there in the news for a long time. For last 1 or 2 months, it was there. What section 43BH of the income tax states? This has been basically introduced by the government, which says that if the buyer is not making payment to the MSMEs, MSEs within a period of 45 days, then what will happen? They will not be eligible for deduction of that amount from their income, and that will be added back into their income, and they will have to end up paying tax on that. So what happens is, I'll just read new MSME 45 days payment rule. An SSE is only eligible to take benefit of the amount actually paid to an MSME entity and claim deduction. Earlier, what used to happen? We used to deduct the expenses based on accrual, that I have purchased this material, so it is deemed that I'll be making some payment. So on the basis of accrual method, I used to deduct the said expenses from my income and used to pay income tax. But now the government has said, no, 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 no. Whenever you will make payment, in that year, you will be eligible to claim deduction, not before that. So what happens if within 45 days, I am not making payment to an MSME? What will happen? I will not be eligible to take benefit of that deduction. Plus, that amount will be added back into my income. I will end up paying income tax. So to avoid or to facilitate payment to MSMEs, government has come up with this rule. When is this rule come into effect? So the applicability, it has come into effect with from 1st of April 2024. So earlier government was, it had to come from 1st of April 2023, but it was postponed for 1 year. This time also, in the month of March, there were many representations from the big industries, FICCI, and all those big chambers, that you please postpone this section 43BH, and that may be taken up from the next year, not now. But the government has made it a decision. All the MSMEs approached the government. They said, we want this rule because we have only suggested, because ultimately it's the payment of the MSMEs which is getting hampered. So until unless this rule is there, we will not be able to get our payments. And usually what happens, the entities, they don't pay MSMEs, and MSMEs are small businesses. They strive for cash, they strive for money. They are always on low capital, liquidity crunch. So if that amount is also stuck up, then MSMEs will not be able to operate. Next. Now, how I will help in getting your delayed payments. What things we can do? So here are some quick tips. We must mention URN on all the invoices. wherever we are mentioning our GST numbers, just below that or wherever it is suiting you, please mention the URN number so that the buyer comes to know as soon as he receives the invoice that I am a registered MSME. Also, at the bottom, specify the payment terms. So if there is a purchase order, even if it is there or even if it is not there, even if there is an email, even if there is a quotation, you must always specify the payment terms on your invoices. That payment has to be made within a period of 7 days or immediate payment or 10 days. Then we must include good defect clause because this is a very valid reason which is being taken by the buyers that goods were not up to the mark or the services were not up to the mark. So what happens in that, if we write or if we include good defect clause, which would usually state that if there is a defect, then intimate us within a period of 7 days from date of delivery. If not intimated, it will be deemed that goods are delivered and there is no defect. So such type of a good defect clause we must include in our invoices. Then we also must state the interest clause on delayed payment. That first we state that payment clause, payment has to be made within 7 days, then interest clause. If payment is not made within 7 days, then interest at such and such percent, maybe 18%, 24%, whatever is feasible, that will be applicable from the date of delivery of goods or from the payment date till the actual date of payment. So if we mention all these things, then buyer will be under an obligation because he knows that you have mentioned URN number. Now 43BH is into existence, everybody knows, so buyer will be under an obligation to make payment. So these are some quick tips of how we can help or how we can quicken or faster our recovery. So now I think we will open the round for question and answers, and I would want that maximum questions I will answer. I will try to answer.
Anybody who likes to go one-on-one, please raise your hand so that we can take your name, unmute you, and you can ask direct questions. Meanwhile, Bhuvanji can answer those questions which are already mentioned in the question answers round also.
Okay.
So I think you all have been
The help is
listening
there.
very carefully. So now it's your time you can ask whatever questions you want, please. Please keep raising your hand so that we can take your name and unmute you. Because
I
we
think
have
there are certain questions.
yeah.
Okay, first let's do one thing. Those participants who are already there, let us answer their questions. Then we'll take up the questions which are raised in the chat box.
Yeah, that's correct, sir. Okay. So can we unmute Aryan Jainji? Aryanji, please ask your question.
Yeah,
Yeah, I
already.
just wanted to know that some party has bounced our check. They had missed the stop payment in the bank. So just wanted to know, should we go for NCLT or should we go for the 138 case in the civil court?
What is the
Its
amount
amount is
of
more
that
than 1
check?
CR.
Amount is?
Hello? Hello? Can you hear me?
Can you repeat? Yeah, can you repeat your amount, please?
Amount is around 130 lakhs.
Okay. Okay. See, we
And
have to.
we have check in hand, but the party has stopped the payment in the bank. So I was not sure that should we go for NCLT or should we go for this 138 to this as a criminal case? Which routes we should adopt?
See, so my question to you is whether you want that party to undergo a criminal litigation or you want your money.
I want my money should get the fastest way.
So yes, so NCLT is the quickest way. Since the amount is agreed, it is undisputed, it is crystallized and more than 1 crore. you must approach NCLT.
Or can I go for both? Is it applicable?
Yes,
I go
yes,
for
yes.
NCLT as well as in the 138 also?
Yes, you can
Is
go
it
for
okay?
both
But
because
the court,
NCLT,
the court will
see,
not dismiss the case, na, that already the party may say if it is already in 138, why they have come to NCLT?
138, I will tell you, 138 is basically a criminal proceeding. It is not a recovery proceeding. And
Okay.
NCLT is also not a recovery proceeding, but we are going in NCLT seeking insolvency of that party. So we are not going to NCLT saying that our dues were there 130 and he has not made payment. This is the check, this is the admitted amount. So you kindly direct that party to give payment to us. No, it is not a recovery court. We will go to NCLT. We will say this is a disputed, this is undisputed, and they have not made payment, so they have defaulted. So they should not default. Therefore, you initiate insolvency. So what happens as soon as we file an application under insolvency and bankruptcy court? The effect of that application getting admitted is such that once that application is admitted, the board of directors of that company, that party buyer, they will cease to have any power. So nobody would want that if that check they have issued to you is for 1.3 crores, I'm sure that must be a big, big buyer. So they would not want that
Yeah.
for 1.3 crores, I should lose my company. They will definitely approach you, they will settle you.
Okay. And as per your experience, how much does it time? Suppose I start process from tomorrow. How much time by and large it will take? I will apply in Delhi NCLT. My
Okay.
registered office is in Delhi.
Okay.
As per your
No,
experience, how much time
we
it will
have to see the registered office of the buyer, not yours.
registered office of the buyer?
Yes, that needs to be seen.
His office is in Gurgaon. I am in Delhi. His registered office is in Gurgaon. My registered office is in Delhi as a seller, and the buyer registered office is in Gurgaon.
So Gurgaon NCLT jurisdiction will be NCLT Chandigarh.
Okay, but like it will, as my registered office is here, so I'll have to go to Chandigarh.
Yes.
Or basically, okay.
Yes, because you are seeking insolvency of that debtor. So where the
Yeah.
insolvency of that debtor will be sought? Where the debtor is situated. So
Okay.
ultimately you will have to go and file a case before NCLT Chandigarh. Previously,
Okay.
also we have filed certain cases in NCLT Chandigarh. Recently, few of the judges have also transferred from NCLT Delhi to NCLT Chandigarh. So we have been appearing before them. So
Okay.
my advice would be you file a case before NCLT Chandigarh, and that is the quickest way you will recover your payment.
Okay. Thank you. And how much time does it take as per your experience in
See, it
Chandigarh
depends
or
upon
this?
documents. Whatever documents are there, but whatever you are saying, if we go by that, it will not take more than 1 year.
1 year.
Less than 1 year.
Less than a year.
Yes, but only if whatever you are saying, that is there on record. If any other thing comes into picture, then obviously the debtor will say, no, there is a dispute, this, that. So that also needs to be taken care of. So
But
once all
once
the
he has
documents
issued
are
the check,
available,
already the payment, he has issued the check. But so I think that only thing he may talk about the quality of the product, service of the products. That is the only two things he
yes,
can not to make the payment.
yes, yes.
Okay, can you advise me some number in Delhi or either in Chandigarh to whom we can approach? Any legal consultant, any legal advocate for NCLT?
You can approach, you can write to UDYAMITA Helpline. They will definitely get back to you.
Okay, thank you. Good to talk to you.
Thank you.
Can we have Sudipti Dhawanji, please? Can you unmute him?
Hi, first of all, many thanks, everybody, to arrange this. I think it's a very important thing that we usually don't end up listening to. So kudos to the whole team. And secondly, I wanted to talk about my own organization, which is not that very big as of now, but we are into service industries. Like we provide digital marketing services in India and abroad. So the basic issue that usually we have is that, sometimes it is a monthly service. So I wanted to understand if the, this purchase order is also liable for these kinds of services? That is my first question.
Okay. Yes, yes.
Okay. So, and second thing is on this monthly service, let's say if we are doing a search engine optimization for any of our client, so do we have to send again and again every month, or will the one purchase order when we get the initial, the work that is suffice for everything?
See, it depends what kind of purchase order and what terms are written in it. If that purchase order is for a period of 1 month, so that purchase order will only be applicable for a period of 1 month. We cannot just go to the court or recover our dues basis the old purchase order, but for a new service. So that
Right.
cannot be done. It can
Okay.
happen that they may issue a generic purchase order saying that
Right.
every month we will take services from you, and for that rates we
Right.
will either revise or maybe rates will be there as written in the purchase order. So even a generic order can work.
Right. Okay, perfect. And finally, the question is like when you say the validity of check, what is
Yes.
the exact validity period that we are looking for over here?
Basically 3 months, 90 days.
90 days. Okay,
90
perfect.
days. Yes.
Perfect. Okay. And finally, when we talk about this 45 days of payment not done, right? We
Yes.
say that we are going to take 3 times interest from the bank. There is this aspect where the relationship is usually spoiled on these kinds of things. So, is there something that can be, put into practice which helps us not to come at this concept only?
Sorry, I didn't get your question.
Like we say that 45 days payment will be like liable for the interest rate, right?
Yes.
Usually even then the clients would not like to pay, and sometimes they would like to pay but not pay the interest. So what is the best way to proceed?
See, that's a commercial call again. It's
Right.
between you and the client. If the client doesn't want to pay any interest and you are getting your principal dues, so it again
Right.
depends upon you that if either you want to take your principal dues back immediately, or you would want to fight a case which may or may not go longer for 1 year or 2 years, and then you want to recover with interest. So it is
Right.
purely a commercial call.
Okay. Okay, perfect. Finally, when we say URN number, is this like related to GST? Because I have not heard about it before.
URN number is basically the number which you get once you register as an MSME.
Okay. Okay, perfect.
So once you get that number, like
Mm-hmm.
we register our company for GST, we get a GST
Right.
number. Once you register
Right.
your company for MSM as a MSME, either you fall
Mm-hmm.
within the category of a micro enterprise,
Mm-hmm.
small or medium. So you
Right.
will get a URN number from the ministry.
Perfect.
So
Perfect.
UDYAMITA helpline also help its clients in getting that number.
Right.
So
Right.
you
Right.
can
Okay.
approach them and they will help you in that.
Right. Perfect. Thank you so very much, Mr. Bhuvan. Thank you.
Welcome. Most welcome.
Can we have Mr. Raghav? Raghav ji, please, can you
Hello.
unmute Raghav ji?
Hello, I'm audible.
Yes, yes, sir.
Yes.
Thank you so much for this educational seminar. I have a question. My company is SAM Experts. We had filed a recovery suit before the court in last month. We also have a check amount.
Raghav ji, your voice is coming pretty low. Can you
Okay,
please?
now I'm audible.
Yes.
Yeah, audible, but
Ah.
voice is coming.
Okay. We had a file a recovery suit before the court in last month. We also have a check amounting to rupees 1.25 crore laying with us from our client. So my question is to you is that whether we can file a criminal case and application for insolvency against our client, and will the recovery suit go hand in hand, both like both of the cases, recovery and criminal suit?
Okay. So what you want to say is you have already filed a recovery suit against your client. However, you also have a check of 1.25 crores with you. So your
Yes, sir.
question is whether you want to go and proceed under check bouncing, Negotiable Instrument Act, or NCLT? And
Yes.
second question is whether the civil suit for recovery and NCLT can go hand in hand. These are
Sure,
two
sir.
questions,
Will
if I've understood
that's
correctly.
right, sir, because we want to
Okay.
go with both or just one at a time.
Okay. Okay. So first is if you have a check of 1.25 crores, as I have already answered Mr. Aryan, he also had a check of more than 1 CR, which is an admitted debt on the part of the debtor. So you can approach the NCLT, file a case seeking insolvency of that corporate debtor. That is the quickest way. So first question is whether Negotiable Instrument Act or NCLT. So my answer to that is NCLT. Second question is, once you file a case before NCLT against the corporate debtor, the recovery suit will cease into effect. It will not be, it will not go on. Why so? Because as soon as the insolvency of that corporate debtor starts, not when you have filed the application, but when that application is admitted. As soon as it is admitted, there is section 14, which says that no recovery can further be made against the corporate debtor. So your suit for recovery will stop from that day immediately.
Okay.
However, saying so, the NCLT is still the quickest way to recover your dues.
Okay, thank you so much, sir. I will, talk to my management and I get back to you. I hope you will help us out.
Definitely.
I have one more question, my personal question actually.
Okay.
Actually, I'm also a home buyer. The builder has failed to hand over the possession of my flat within a speculated time. So what do I do now? What I have a legal rights like that
See,
to
as a
me?
home buyer, you have various rights. You can either, approach the NCDRC, which is the National Consumer Forum. You can approach RERA. You can also approach NCLT. But for approaching NCLT, there is a provision that either 100 home buyers of a particular project have to be there, or 10%, whichever is less. So if the number of home buyers are there, then jointly you can file an application against that builder.
Okay,
Or
okay, sir.
in the alternate, you have two options, either to approach NCDRC or to approach RERA.
Okay, sir. Thank you so much, sir.
Most welcome.
Can we have Jatin ji? Please unmute Jatin Shah ji, please. Please ask your question, Jatin ji.
नाइन्टी डेज का अगर मैं एलसी टर्म्स डालता हूं तो क्या एमएसएमई में एप्लीकेबल है?
सॉरी, 90 डेज?
अगर मैं एलसी टर्म्स में मिनिमम 60 डेज या 90 डेज है, बायर अगर एलसी ओपन करता है, देन वी हैव सप्लाइड द मटेरियल अगेंस्ट एलसी, तो वो एमएसएमई 45 डेज के एक्ट में आता है या नहीं आएगा?
नहीं, वो तो आपका देखो बैंक के साथ वो डील हो रहा है। एलसी आपने 60 डेज की वो करी है, बट अगर हम बायर से बात करेंगे, बायर को तो पेमेंट करना ही है ना 45 डेज में।
नहीं,
45 डेज का जो कॉन्सेप्ट है वो कहाँ आता है? अगर हम सिर्फ और सिर्फ एमएसएमईडी एक्ट में अपनी रेफरेंस फाइल करते हैं, इन नॉर्मल सर्कमस्टांसेस इट विल नॉट कम इनटू इफेक्ट।
नहीं, लेकिन अब हम लोग सप्लाई करेंगे तो वो तो बैंक से पेमेंट हमको तो 60 डेज में मिलेगा अगर एलसी टर्म्स में है तो उस टाइम के लिए, उस पीरियड के लिए फिर 45 डेज का एक्ट नहीं लगेगा ना एमएसएमई का इस ट्रांजेक्शन में?
नहीं, देखो जब बैंक से आपका एलसी लिमिट सेट हो रखा है,
हाँ,
तो वो तो बैंक आपको 60 डेज में ही देगा। ठीक है ना? तो वो
हाँ,
तो क्लियर है, वो 60 में ही देगा।
तो वो एमएसएमई 45 डेज का एक्ट नहीं लगेगा ना, फिर उसमें हम लोग क्लेम नहीं कर सकते ना।
45 में ऐसा होता है कि देयर इज वन सेक्शन इन एमएसएमईडी एक्ट 24 or 25 which says that nothing contained in nothing inconsistent contained in any other law for the time being in force, this act will prevail over any other act। तो वो बैंकिंग एक्ट को भी ओवररूल कर रहा है। तो अगर बैंक नहीं मानता, मैं एमएसएमईडी में जाता हूँ, तो मैं वहां पे 45 डेज का वो दिखा के आई कैन विन माई केस, बट दैट इज अगेन एंटरिंग इनटू लिटिगेशन, unnecessary litigation,
राइट।
so if I am getting my payment within 60 days, it's good that I am getting my payment।
ओके, सेकंड थिंग, हम लोग सप्लाई करते हैं ट्रेडर्स को। अगर ट्रेडर्स अगर 45 डेज में पेमेंट नहीं करता है तो क्या मैं लीगल टर्म्स में जा सकता हूँ, लीगल एक्शन में?
ट्रेडर्स अभी जो 43B(H) सेक्शन जो है उसमें ट्रेडर्स कवर नहीं है अभी।
हाँ,
राइट, तो वो कवर्ड नहीं है। तो वो अभी अगर कोई नोटिफिकेशन ऐसा आता है फर्दर बाय द गवर्नमेंट तो तब वो उनके ऊपर भी एप्लीकेबल।
ओके। और सेकंड थिंग, लास्ट क्वेश्चन, रिकवरी के लिए अगर हमको फाइल करना है तो क्या टाइम लिमिट है कि 1 साल पहले का पेमेंट है तो नहीं मांग सकते, या 2 साल का, ऐसा कोई टाइम लिमिट है?
हाँ, टाइम लिमिट होता है रिकवरी के लिए। टाइम लिमिट जो गवर्नमेंट ने फिक्स किया है वो एक लिमिटेशन एक्ट के थ्रू फिक्स किया है, जो कि जनरली 3 years रहता है
ओके,
फ्रॉम द लास्ट डेट ऑफ पेमेंट रिसीव्ड फ्रॉम योर बायर, या फिर कोई ऐसी एक्नॉलेजमेंट बायर ने की हो जिससे 3 साल के अंदर अंदर आपको केस फाइल करना पड़ेगा। क्योंकि व्हाट हैपेंस, अगर आप कोई भी कोर्ट में जाओगे 10 साल बाद तो जज का सबसे पहला क्वेश्चन यही होगा आपसे कि आप 10 साल से सो रहे थे, और ऐसा
राइट,
हुआ है बहुत पहले।
राइट,
तभी फिर जो लेजिस्लेचर ने एक ये नया एक्ट बनाया, लिमिटेशन एक्ट, इसमें क्लियरली लिखा गया कि अगर आप 3 साल तक अपने पैसे नहीं रिकवर करते हैं तो उसके बाद यू डोंट हैव एनी राइट टू रिकवर योर मनी। इफ यू आर स्लीपिंग ऑन इट देन स्लीप ओवर इट। तो ये जजमेंट्स भी है सुप्रीम कोर्ट की विच सेज फॉर 3 years पीरियड।
एंड वन मोर थिंग, अगर हमने किसी को चेक इश्यू किया है लेकिन उसके ऊपर डेट नहीं लिखा है तो 90 डेज की वैलिडिटी में 5 साल पुराना चेक है तो क्या वो डेट डाल के यूज कर सकता है ना?
डेट जब आपने नहीं लिखा है तो डेट तो वो डाल ही सकता है ना।
वो 90 डेज के अंदर ही वो आ जाएगा, बराबर ना? मतलब पुराना चेक भले 5 साल पुराना, लेकिन चेक की वैलिडिटी है तब तक तो चेक
नहीं, चेक
रहेगा।
चेक पुराना तो है ही नहीं ना, वो तो अनडेटेड चेक है, तो पुराना तो है
ओके,
ही नहीं वो।
राइट,
उसमें तो जब डेट डलेगी तभी से उसकी वैलिडिटी स्टार्ट हो जाएगी।
ओके, थैंक यू।
ओके, ओके, मोस्ट वेलकम।
Please connect with Roshan ji. Unmute him.
Madam, I got the answer. I got the answer. I want to know what is URN number. I got the answer during discussion.
Thank you, Roshan ji. We have pinned our address, phone number, everything in the chat box. You can get in touch. Subhash ji,
Subhash is
please.
there.
Yes, Subhash ji. Can you unmute Subhash ji? Would you like to ask? Subhash ji, please ask your question. Okay. Okay. Pooja ji is there. Pooja ji, please ask your question.
I have a question regarding MSME returns form 1. हाँ, एक्चुअली ये रिटर्न्स हमें जो फाइल करनी है तो ये किस पीरियड से फाइल करना था?
हेलो,
हेलो,
हेलो।
am I
Subhash ji,
audible to you?
Pooja ma'am, please continue with your question. Subhash ji, you
Sure.
need to go. Next is you.
सो MSME फॉर्म 1 का हमारा वैलिडिटी मतलब पीरियड हमारे ऊपर कब से एप्लीकेबल था वो फाइल करने के लिए?
आज एक्चुअली पूजा जी वी आर ओनली टेकिंग इनटू अकाउंट द डिलेड पेमेंट इश्यूज। आज का जो हमारा टॉपिक है, जो आपका एक क्वेश्चंस है आप चैट बॉक्स में डाल दीजिए।
श्योर,
ठीक है, somebody from my team will definitely get back to you and answer your query.
ओके, श्योर, थैंक यू।
Right? Okay, okay.
Anji Subhash ji, now you can ask, please. Please unmute Subhash ji.
Okay. I have read somewhere that MSME registration cannot be taken retrospective. Hence, prior registration of the enterprise before the date of disputed invoice is mandatory for filing the application. How
Yes.
it stands?
Yes, you have read it correctly. Because what happens that if some party has raised a dispute and I want to take benefit of that, so courts have said no, now you cannot take any benefit.
Right.
Had you been an MSME registered earlier, then we could have taken or entertained your case. But now you want to take the benefit and you have just got yourself registered, you will not be entitled. What happens in future, for future cases, for future references, if we get our entity registered as an MSME today, at least we will be entitled for all the,
Future
interest
reference.
and everything and every benefit which are being, given by the ministry.
Okay. And another thing, this MSME is for different states, laws are different, or it is same for all the cases?
It is same. It is same.
Okay, okay, okay.
It is a
And
central
another,
act.
right,
So
right.
laws are same for all the states.
Okay, sir. And another thing, you are talking about this 43 section of income tax.
Yes.
Suppose during the year end, before finalization of the year, someone makes the payment with someone is not making payment within 45 days, but at the year end he doesn't have any balance. All the dues are cleared. In that case, that will be affected or not?
That will be affected.
क्योंकि वो जो एडबैक होगा सर, वो तो आपका 31 मार्च के बाद में जब when we will file our return, तो उसमें तो रहेगा नहीं कि because all the payments will cleared by that time. Only the remaining payment which we have not made within the 45 days, those will be considered only, ना? That I want.
इसमें एक्चुअली क्या है, इसमें अभी मिनिस्ट्री ने ना कुछ क्लैरिफिकेशन नहीं दिया इस पॉइंट पे.
अच्छा.
Because if it is not made within 45 days, but made say after 3 months, then what will happen within the same financial year? तो इस चीज पे अभी क्लैरिफिकेशन नहीं आया मिनिस्ट्री की साइड से कि क्या वो लिया जाएगा, क्योंकि अभी आज 25 दिन ही हुए हैं इसको एप्लीकेबल होते हुए. तो अभी ये इश्यूज आएंगे. अभी तो ये शुरुआत है इस फेज की. इश्यूज आएंगे, हो सकता है आने वाले टाइम में 2 महीने 4 महीने में कोई क्लैरिफिकेशन आ जाए, क्योंकि 45 डेज तो आज से ही स्टार्ट हो गए 1 अप्रैल से.
ठीक बात है, ठीक बात.
तो कुछ क्लैरिफिकेशन आएगा मिनिस्ट्री के साथ.
ठीक है सर. थैंक यू वेरी मच.
ओके.
Can we have Chandrasekhar ji? Chandrasekhar ji, please ask your question. Okay, Yudhishthir ji.
Done, ma'am.
Okay.
Hello.
Okay, Yudhishthir ji, please ask your question.
Okay. Am I audible?
Yes, please.
Yes, you are.
No, unmute
Okay.
Chandrasekhar ji. Please let Yudhishthir ji ask
Hello.
first.
सर मैं एक केस पे आपकी थोड़ी कंसर्न चाहूँगा. टाटा प्रोजेक्ट्स को एक्चुअली कंस्ट्रक्शन के बिजनेस में है, तो एक टाटा प्रोजेक्ट्स से हम सब कॉन्टैक्ट में थे.
Can you please be a little louder? आपकी आवाज थोड़ी कम आ रही है.
ओके ओके. जस्ट अ सेकंड. अब सही है सर?
हाँ बिल्कुल.
हेलो जी सर, एक्चुअली हम टाटा प्रोजेक्ट्स के साथ एक सब कॉन्ट्रैक्ट में थे एक प्रोजेक्ट पे. गवर्नमेंट प्रोजेक्ट था, तो एक्चुअली वो कुछ फंड्स की वजह से वो अभी बंद पड़ा हुआ है कुछ टाइम से, 3 साल के करीब. तो लास्ट ईयर हमने टाटा प्रोजेक्ट के साथ नेगोशिएशंस करे पेमेंट्स के लिए. तो एक्चुअली हमने फंड्स की आज करीब ड्यू था, तो उन्होंने हमारे साथ जो नेगोशिएशन किया, तो उन्होंने अराउंड 50 lakhs हमें उस टाइम पे कर दिया 1 ईयर पहले. और उन्होंने जो बाकी रिमेनिंग 50 lakhs था उसके लिए 16 lakhs के लिए वहाँ सिक्योरिटी डिपॉजिट था, और 34 lakhs करीब उन्होंने जो हमारा अनबिल्ड अमाउंट है, उन्होंने अभी इनवॉइस एक्सेप्ट नहीं किया उस चीज़ के लिए. और जो उसके लिए उन्होंने एक एमओए हमारे साथ में किया है कि इफ 2 साल के अंदर अगर क्लाइंट से हमें पेमेंट नहीं मिलता है, तो हम आपका 2 साल के बाद टाटा प्रोजेक्ट्स विल बी लायबल टू पे दिस.
ओके.
So is this MOA valid after 2 years?
Yes, that will be valid. बट आप अपने जो प्रिंसिपल डेटर है, आप उसके अगेंस्ट रिकवरी केस फाइल करिए ना. व्हाई आर यू वेटिंग फॉर 2 years टू गेट योर पेमेंट?
नहीं, एक्चुअली हम प्रिंसिपल डेटर ही हमारा टाटा प्रोजेक्ट्स है, बट उन्होंने एक एमओए हमारे साथ किया, तो उन्होंने कहा चलिए 2 साल वेट कर लीजिए, अगर नहीं होता है तो फिर हम ही आपको पे करेंगे. एक्चुअली उसमें एक क्लॉज था कि बैक टू बैक पेमेंट, उन्होंने पता नहीं.
अच्छा, आपका बैक टू बैक
जब क्लाइंट हमको, हाँ उन्होंने कहा कि जब क्लाइंट हमको पे करेगा तो हम आपको पे करेंगे.
ओके. So now the question is, once you have signed that MOA with Tata Projects, how can you back out from that MOA? So you will technically wait for 2 years to get complete.
we are not backing out. We are just asking कि if 2 साल के बाद अगर वेट भी करता है तो deny तो नहीं कर सकते ना SMOA को कि
then you can file the case. अगर 2 साल के बाद अगर पेमेंट नहीं आती है, then you can file the case. They will be duty bound to take care of your dues. They will have to make payment.
ओके, और ये सिक्योरिटी डिपॉजिट के लिए भी फाइल कर सकते हैं क्योंकि प्रोजेक्ट तो भी अटका हुआ, प्रोजेक्ट पूरा होगा
देखिए,
नहीं।
नॉर्मली सिक्योरिटी डिपॉजिट अगर आपने दिया है और आप टाटा प्रोजेक्ट्स की बात कर रहे हैं तो आपको वर्क ऑर्डर इशू हुआ होगा।
जी बिल्कुल
और
है।
ये वर्क ऑर्डर का पार्ट ही होगा कि उसमें 2% या 5% सिक्योरिटी विल बी डिडक्टेड एंड इट विल बी डिपॉजिटेड एंड इट विल बी इशूड और गिवन बैक व्हेन यू कंप्लीट द प्रोजेक्ट और व्हेन आफ्टर द कंप्लीशन ऑफ डिफेक्ट लायबिलिटी पीरियड, जो कि नॉर्मली केसेस में होता है। तो जब वो पीरियड कंप्लीट हो जाएगा, यू आर एलिजिबल फॉर गेटिंग योर सिक्योरिटी बैक।
हाँ, बट सर वो प्रोजेक्ट एक्चुअली अटका हुआ है तो उसमें कंप्लीट होने कोई चांसेस नहीं है, तो क्या रिकवरी के लिए हम ये फाइल कर सकते हैं? और बैक टू बैक का क्लॉज भी है इसमें, तो जब तक उनको अगर सिक्योरिटी डिपॉजिट नहीं मिलता तो शायद वो भी ना दें।
आप एक काम कर सकते हैं, आप हमें उद्यमिता हेल्पलाइन को आप डॉक्यूमेंट्स एक बार शेयर कर सकते हैं या उनको एक बार कॉल कर सकते हैं। वन ऑन वन वी कैन डिस्कस आफ्टर शेयरिंग योर डॉक्यूमेंट्स, आफ्टर एनालाइजिंग योर डॉक्यूमेंट्स, एंड देन वी विल बी इन अ बेटर पोजीशन टू हेल्प।
ओके सर।
क्योंकि अभी एग्रीमेंट में क्या लिखा है आप मेरे को भी नहीं पता एग्जैक्टली क्या लिखा हुआ है, कितना सिक्योरिटी है, क्या एमओए हुआ है, क्या एमओए में क्या क्लॉज लिखा हुआ है। तो आई हैव टू गो थ्रू एवरीथिंग एंड देन ओनली आई विल बी एबल टू एडवाइज यू इन अ बेटर मैनर।
ओके सर, जस्ट वन लास्ट क्वेश्चन। हेलो।
हाँ जी, हाँ जी, प्लीज आस्क।
जी सर, हम पे एक्चुअली उद्योग आधार है दिस
यूएएम, उद्योग आधार मेमोरेंडम।
हाँ, मेमोरेंडम।
यस,
उद्योग आधार मेमोरेंडम, उद्योग आधार।
तो उद्योग आधार मेमोरेंडम जो आपके पास है वो पहले होता था, उसके बाद देयर वाज अ नोटिफिकेशन बाय द एमएसएमई मिनिस्ट्री which stated that अब जितनी भी एंटिटीज हैं उनको यूआरएन नंबर लेना होगा। तो बेसिस दैट अब आप अपना यूआरएन नंबर के लिए अप्लाई कीजिए और वो आपको मिल जाएगा। ऐसा नहीं है कि उसमें कुछ बहुत टाइम लगता है या वो है। आपके बेसिक डॉक्यूमेंट्स अपलोड होंगे और वो मिल जाएगा। उद्यमिता हेल्पलाइन इज देयर टू हेल्प यू आउट। अगर आपकी कुछ क्वेरीज हैं, आपको कुछ इश्यूज आ रहे हैं वो ऑब्टेन करने में, तो यू कैन अप्रोच उद्यमिता हेल्पलाइन।
ये जस्ट एक ऑटोमेटिक, मतलब हमको रजिस्टर तो उसी दिन से माना जाएगा ना, ये तो नहीं न्यू एप्लीकेंट होगा ये एज।
आप एक बार उद्यमिता हेल्पलाइन को कॉल करके अपना नंबर छोड़ दीजिए, दे विल गेट इन टच विद यू और आपकी जो भी कोई क्वेरी है रिगार्डिंग रजिस्ट्रेशन ऑफ यूआरएन, दे विल बी एबल टू हेल्प यू।
ओके, थैंक यू।
वेलकम।
Chandrasekhar ji, now you can ask your question, please. Please ask your question. हाँ जी।
Sir, first of all, thank you so much for this most informative session. I have a collective question.
Okay.
I'll conclude in a like I'll tell you. See, we run a fabrication company called System Rack Technologies, and we do the sheet metal fabrication. We have many non MSME customer like ABB Schneider, and as well as the MSME customer also. Hello.
Yes, yes.
And what happens, we receive the purchase orders, like the payment terms defined like 90 days, 120 days, sometimes it's go 180 days also, but most of the case it has been written in the purchase order. We accept those POs because of the market competency, as you explained in the beginning session.
Yes.
The competition, we accept the purchase order and we supply the material, and some of the cases it will cross 90 days also. And as well as the same thing apply to my supplier also, where we stimulate in our PO saying that 90 days, 120 days, and we pay the payment according to that 90 days, 120 days. In this case, how this new clause going to be fit and how can we get the claim of it? Whether if we get the payment within 45 days from my customer, I'm able to pay to my supplier also. Since we are very small company, like our turnover is less than a 20 crore, so we still doesn't know whether we have to make the payment to our supplier within 45 days, even though it has been defined in the PO like 90 days or 120 days. If we have to pay to my supplier, how this will going to be applied for my customers?
Okay. So first of all, you will have to tell your customers about this new section, that even if there is a purchase order, highlighting a payment which is beyond the law, that
How?
will not suffice, because the law now states that you have to make payment within a period of 45 days. First, if they are not making payment within a period of 45 days, then you need not have to file any case. They will not get
Oh,
benefit of that. They will have to end up paying income tax on that, which is 30%, because this
got
law
it.
is applicable to all.
And we have to pay to our supplier within 45 days also. The same
Yes,
thing.
if your suppliers are MSMEs.
Most of the cases are 99%
Yes,
they are the
yes.
same.
So then within 45 days, because
And
what will happen, end of the year, when your chartered accountant will sit, or when the auditor will sit, he will ask the first question, that what were the payment terms and why you have not made payment within 45 days. So all these expenses which we would have taken into care will be disallowed by the income tax, and we on that we will have to end up paying income tax.
and even if our customer they are non-MSME or MSME, they have to pay us within 45 days.
Yes, yes, because we are
Okay.
MSME, but we need to inform
Yes.
that
And
we are MSME.
yes, sir. And I have a question for this.
Okay.
What will happen? The big player, like as I explained, ABB, Schneider, and many, they're trying to squeeze the small scale supplier always. What they'll do, they'll come up with a new solution saying that give us the declaration like we accepted to give us material 90 days, 120 days as a special condition. Like that, they'll insist us to take the letterheads or something else, because if we don't do that, they can able to go with the other competitor. Is there any chances can they able to take such kind of a letters from us by forcibly?
See, even if they take letter, they
Oh,
cannot surpass the law.
oh, super.
What if I put across to you that, okay, you start selling, guns and bombs and, ammunition openly in the market, which is illegal.
Yeah,
Can
yeah.
you sell that? And if you get caught, I will take care of your case. I will get you out. If even if we enter into that kind of agreement, it's illegal.
Yes.
So one cannot surpass the law, even if they have taken such kind of assurance or anything on the, on a letterhead or any understanding. They cannot surpass the law. If law
And
is
this,
there that payment has to be made within 45 days, else expenses will be disallowed. It is there. It is written in the income tax. You and me are not, changing the income tax act. It is by the government.
will this going to be implemented from this financial year or from the
Yes, it
previous
is
financial
already
year?
been implemented with effect from 1st of April this year.
This is actually a resolutional. I mean, the law, if they invent it and if they install it properly. Because what will happen for a MSME or a small companies, for new companies, the biggest challenge is to get the payment. It is
Yes,
literally, it's like a nightmare for us. It is
yes,
we can't
yes,
able to explain it. It's the same problem for 90% of the MSME companies. If
yes,
this law get adapted properly, I'm very sure the resolution will be happen in the industry. Like newcomers will come, and even it will be help for the growth of the MSMEs also.
yes. So of the suggestions given by the MSMEs only, government has passed this law. I was just reading one. I was just looking at one video of our finance minister, Miss Nirmala Sitaraman. She was saying that this suggestion has only come from MSMEs, that you introduce this rule. And now MSMEs are saying, no, no, the buyers are not taking materials from us because we are telling them this law has come. So they are approaching some other competitor who is not an MSME or who has not obtained the Udyam registration.
Yes, yes, that will happen in. That is the way we are scary about. If
Yes,
most of the
yes,
case, what will happen? Ultimately, the customer want to buy the material with cheaper rates.
yes. So what will happen is, initially, there will be troubles, but sooner what will happen, it will become a competitive market. It will become a flat, ground for everybody to play.
I've been in the purchase department since 1 decade. I gone through. I handle the suppliers. I gone
Okay.
through the different situation. Like the payment is everything for a supplier. So if your
Yes,
supplier or if your material provider can't get the payment on time, the complete cash crunches happen very badly. The business can be get shut down. So if this is going to be implemented properly, really it will be a resolutionary moment. And thank you so much for your this information. And now onwards, I'll ask my accounts department to clear my supplier payments within 45 days.
definitely,
He's
definitely.
also listening this audio. I told
All
him
the
n
all
number
the
of
quick
times.
tips which I have shared, you must incorporate those in your invoices.
Definitely, definitely. I always insist my supplier to, sorry, my accountant to clear supplier payments within 45 days. But
Yes,
he's stick to old school formulas and he never make the payments. Even in April also, he is not making the payment within 45 days. So now I will insist him to clear the payment within 45 days. And as well as I'll remind my customers to get the 45 days payment.
definitely.
Thank you, sir. Thank you, sir. This
Most welcome.
session was eye opener for us. It was very informative, sir. Thank you so much.
Thank you. Thank you. Most welcome.
Please unmute Devi ji. Please ask your question.
Sir, good evening. Thank you so much. This session was really very informative for us. So much of valuable information we got. Actually, we have a customer to whom we have supplied the goods, and an amount of around 5 to 6 lakhs is pending from him to us
Hmm.
for the past 2 to 3 years. So, which one of this rule will be applicable to me to claim that amount from them?
See, your outstanding from the customer is 5 lakh.
5 to 6 around. But
Okay.
it is pending for more than around 3 years. I think not completely 3 years, from 2 to 3 years it may be.
Okay.
I
So
have
it
to
is,
check exactly. I have
I
to check
think,
the
I
invoice date.
think, Deviji, it is high time you must act and approach the court, because if that period of 3 years will lapse,
Uh-huh.
nobody will be able to help you out.
Yes, yes, correct, correct. So which one I can now file a suit for this recovery, correct?
No, it depends upon what kind of document you have entered into. Suit for recovery, as I told in the webinar, also has two categories. One is recovery suit, one is summary suit. So only after seeing the documents, we can help you with the correct position of law and correct court where you can file the case.
No, actually we are having the purchase order copy from the customer, and we also have the invoice copy of us.
Okay, then summary suit is a good option for you.
Summary suit. Okay.
Yes.
So I have to file here in. We are based in Chennai, so we have to file here Chennai jurisdiction only, right?
No, where the office of the debtor, the buyer is situated, or if you have supplied goods from your place of business, then you can file in your place.
He is in Bhopal right now, Madhya
Hmm.
Pradesh.
But if you have supplied the goods from your place of business, then you can file the case there also,
There, here
within
from
your
here.
jurisdiction.
Yeah, yeah. I have supplied the goods from Chennai only, so I can
Yeah,
file
yeah.
here itself, right?
Then you can file a case in Chennai district court.
Okay.
Yes.
Okay, sir. Thank you so much.
Okay. Most
Thank
welcome.
you.
Subhashi, please. Acha, Sagir Raju. Mr. Chandrasekhar, please ask your question. Please unmute
Yeah, good
Chandrasekhar
evening.
ji.
Good evening. Good evening. Am I audible?
Good evening.
Thanks. Thanks all of you, Karthik and the entire team, for organizing this particular briefing series session. I have one specific question. I'll just go through fast. See, we have an order from the company where we are service providers, and we had entered into a contract with the principal company saying that 90% of the order value has to be paid in case the work is not complete as per the order terms. Because we invest almost 70 to 80% of the money for mobilizing, keeping the manpower there, and doing the job, bringing them back, travel expenditure, all those things. So we had put a clause that 90% has to be paid, and order also was released saying that 90% will be paid. Why we had this clause was most of the time the give us order for say 1 crore rupees, but they get the job done only for 40 lakhs, 50 lakhs, our overheads doesn't get covered up and we end up losing. So we had this clause. The order was released on us saying that 90% paid. So for some reason, after we mobilized due to customers related issues, the work did not get completed and they had to short close the shutdown activity. And they were bound to pay us 90%, but because they had their own compulsions from their top management, they tried to, discourage us from claiming that 90%. But because we were also stressed, we ended up running behind them for more than 1 year. Then finally, we got around 40-45% of the order value recovered. So balance 40-45% is still there, unrecovered. They are not taking our bills. So what do you suggest that I do? Either I ignore or I just take it up with NCLT or any other authorities?
Okay. So just try explaining things. What is the purpose? What is the scope of business for you? What was the scope of work?
Our scope of work was to do a cement plant refurbishment work.
Okay. Okay.
It is a manpower dependent work which involves good amount of expenditure for travel
so
and
you did not ask for mobilization advance?
No.
Okay.
No, we had asked for some advance, but not for mobilization purpose.
Okay.
And they did pay us for the advance money, but the order terms was, if the work is not as per the inquiry, or if the quantum of work is not completed as per the inquiry, for reasons attributable to customer, not for us,
Okay.
then they have to pay us 90% of the order value, because that covers all the expenditures that we incur.
So at least margin, okay. So margin will go away, but at least whatever amount you have incurred as expense, it will come.
Yeah.
Okay.
They placed an order on us saying 90% will be released. But for some reason, after the plant was taken for a shutdown, they had to restart the plant much before they could complete all the shutdown plant activities. And our volume of work that we completed was much less.
Okay. So what is the outstanding as of now?
They are not taking our invoice. Initially, they had paid us around say 25 lakh rupees. Then after a lot of follow-up, 6 months, they did not take the call. They gave excuses. Somebody was not well. Somebody was sick. They dragged it for 7-8 months. It was almost 1 year from the time that we got the order. Finally, we recovered another 20%, 20-25%. So totally, we should have recovered almost around 45% of the order value. Submitting invoice only for that 45% of the order value. For the additional claim, they are not giving us time nor approval and they claim that next shutdown we'll try to manage and all this stuff, but that doesn't happen normally.
Okay. So I think NCLT might not, because whatever it is sounding from you, NCLT might not be a good option because there is a serious dispute between the quantum and the work done as they are raising.
Can I come in?
The NCLT would not be a feasible option because they are raising a dispute with respect to the quantum of work done and the quality of work done. So they have already raised a dispute.
Can I come in? I want to just correct it. There is no issue as far as the quality of work done.
Okay.
But the quantum of work done was not released by, so that's why it could not be done. It was not that we did not want to do, but for their own reasons, they did not give the funds for us to complete the ordered quantity of work.
Okay. So do you have emails with that respect?
No, we have emails. No, we have sent mail, but they did not reply. But we have an order which clearly says, if the quantum of work is less than the ordered value, 90% of the ordered value will be paid.
Okay. Okay. Then that outstanding amount, the remaining 40 or 50%, whatever is outstanding in that 90% value, does that exceed 1 CR?
No, it doesn't exceed 1 CR.
Then NCLT is not.
Okay, it doesn't exceed 1 CR. Now my challenge is, for the balance part of the order, we have not submitted the invoice which they are not taking, number one. Suppose I raise an invoice, then I have to pay for the GST. So which I don't know when we will be able to recover.
Have you raised? You may raise PI for that.
Pro forma invoice, yeah.
Yes. So that, and send them over email so that they get the PI also. And once we approach the court, we can show the court that through this email, we have already sent all the invoices, PIs to them.
Okay. PIs should include the GST also?
No.
Okay, excluding GST, we can raise the PI.
Excluding GST, you raise the PI.
Okay, thank you very much.
And you may write that the invoices will be raised once you make the payment, or you can include the GST also. In the PI, you can say that this is the principal amount, this is with GST, total is this. Once you make the payment, we will raise the invoices.
Okay, done. Okay, thank you. Thank you so much.
Okay, most welcome.
I think we've answered each one of. Is this Subhashji still wants to ask something?
Yeah, I think so.
Subhashji, would you like to ask another question? You can unmute him and check whether he is there or not. Or Bhuvanji, we can just answer a few of the questions which are mentioned in the chat.
Okay.
Before we just run through.
So there was one question by Mr. Aryan. Does stop payment also come under check bounce? Yes, it comes under check bounce. Any kind of dishonor of the check, any reason, will be considered as check bounce, be it any reason. Then it says another question from Mr. Shivam. If we write on invoice that in case of dispute, such place will have jurisdiction, is it valid? See, it is not valid in case of our invoice. What will be valid will be the purchase order, or if an agreement is there signed by both the parties, and in that case, suppose I am from Delhi and the other party is from Kerala, and we write that in case of dispute, Bombay court will have jurisdiction, then that will be applicable, because in an agreement both the parties have signed and agreed upon something. But if I mention in my invoice, then it will not be valid, or it will only be valid if it is accepted by the other party. Then there is a question by Anupam, I think. Sir, what we can do if company is already been bankrupt? Okay, so if company is bankrupt, by bankruptcy, you mean that insolvency and bankruptcy proceedings are going on, or you yourself are saying that they are not in a position, hence they are bankrupt? So there are two different things. If the company is itself saying that I am bankrupt, I can't pay your dues, then they are actually not bankrupt. You can go and legally recover your debt. However, if that company is undergoing insolvency process through a court, then an option is available to you to lodge a claim before the insolvency professional, or in case the company is under liquidation, to lodge a claim before the liquidator. That is the only option. That is how you can recover your payment. Then
So in the question answer thing, there's a question by Mr. Lakshman, and he's requesting if you can answer that. He's mentioned his question, the question answer thing.
At what
Mr.
time?
Lakshman Khalkar.
Can you tell me? Okay. Dear sir, we work with defense PSUs. Their payment terms are within 30 days from the date of acceptance. However, there is no limit on the days in which they have to accept the goods. They exploit this loophole. Accept our goods after 5-6 months, and after that they make payment. How can we go about it? Okay, so Mr. Lakshman, when they issue the purchase order, you can revert to their purchase order with the condition that though I am accepting this purchase order, but the acceptance of good will be from the date the goods are delivered. First, in case they don't revert to that, in the invoice, you can write the goods will be deemed to be delivered when they are actually delivered. Third, if you are going to MSME court, MSEFC councils, there is a clause, there is a section which states that goods are deemed to be delivered on the day they are delivered, and then there is no defect. And they have to make the payment within 45 days. But in your case, it is 30 days. So if they are delaying it for about 5 to 6 months, you can approach MSEFCs. However, it is again a business call. If you are doing a good amount of business with them and you don't want to lose them, then you might have to wait for 5 or 6 months. And I think most of the queries we have answered, they relate to only 45 days, 43BH. I think we have already answered most of them. In case there are any other queries, you can write down in the chat box, and we will definitely get back to you.
I think we already done with it. So on behalf of everybody today, wholeheartedly, I would like to thank Bhuvanji for sharing his valuable time despite his busy schedule. And I would also mention that even I have learned today the small detailings of filing a PO and sending invoices, and what is the role, follow-up mails and WhatsApp and arbitration and filing suits, and how mediation works. So like being a knife, I have learned so much. So people who were here with their problems, I'm sure they have their answer today. And I request once again, each one of you, please, if you still have queries, you can get back to us. We have pinned a number, and we'll get you directly in touch with Bhuvanji. And I'm sure he's going to help you. He does not only hold hand, but he will take you until the right way to do it and how to do it. You have seen him explaining the small detailing. So I think it was such an engaging and informative session where we didn't even learn from each other experiences, but we now know how to go about it, like from the scratch. So once again, thank you so much, Bhuvanji, for being a part with us for such a valuable lesson today for each one of us. And thank you so much. God bless you. And thank you to each one of you, all the participants here. Thank you for joining us. And do put in your comments that how did you find the session, and we'll get back to with Bhuvanji again very soon with some new problems to be answered.
Thank you, Sonia. Thanks for inviting me.
Thank you. Thank you.
Okay.